My lord, in this situation, the urgency is, my lord, in the meantime, they have served a notice for improvement by 32 of FSS Act.
The personal appearance.
Personal appearance was there, na?
Yes, my lord.
Whenever there is personal appearance, call them at the top of the list. Because officers, I cannot make them wait here. Yes.
Exactly. My lord, with due apology, my lord, the officer is coming on the way. He's
On the way?
getting a pass.
No. Possible.
He's there. He has come. With,
SP is here.
no. He is the district education officer, Kandrapara.
Why you were there for this? Will you find?
Lordship,
Just go to a serial number
30.
30.
May I submit, my lord?
Yes.
My lord, your lordship, on 30/8/2025, disposed of the writ application by giving the following order. London Council for the petitioner submits that the said representation having not been considered, and reminders sent to all the higher officers, including Chief Minister of the state, having not yielded any result. This court should come to the aid of this poor client. He quotes Article 350 of the Constitution of India in support of his submission. London Council, London AGA, operative portion is in the above circumstances. The writ petition is disposed of. Time for consideration of representation and informing the result of such consideration to the petitioner is 8 weeks. Reckoned from this day.
Yeah.
All contentions of the parties kept open.
Have they done within 8 weeks?
No. They have done it yesterday only. My lord, they have.
Let them pay 1 lakh rupees each. How many have to take the decisions?
My lord, unfortunately, the period for which it requires, my lord, to consideration, my lord.
You should have put the application for extension of the period. I would have taken.
Exactly. That yesterday I was suggesting him, if you cannot trace out the documents of the petitioner,
Let them pay 1 lakh rupees each.
then, my
How
lord,
many have to take the decision? Who have to take the decision?
one the DO.
Let the DO pay 1 lakh rupees to the concerned petitioner.
My lord, lordship is what?
No. Otherwise,
My lord.
we can't run the government at all.
My lord,
Officers think that they are all descendants of
no,
East India Company.
here is a case. It is a matter of 2000.
All that is over.
My lord.
8 weeks time was granted.
My
What
lord.
this officer was doing. Why should not you send him home?
The lordship is right. But, my lord, lordship may kindly consider it, my lord. They have already
How many
implemented.
times we fix the time?
My
Well,
lord.
contempt, first contempt, second contempt, third contempt.
No,
That is that we are playing
No, no.
with the lives of people.
No, my lord, I am not allowing them for first, second, third. I am first instance, you have to implement
Where
the
is your advocate for the petitioner? I will keep that officer at the mercy of the petitioner's counsel. If petitioner counsel agrees, I will pardon him. Otherwise, I will pass it. Which is the next level of promotion for him. I will spoil his records. I will spoil his service records.
My lord.
That is the only way the language with these officers, they think that nobody can do anything to us. That is their impression.
No,
But
my lord.
we will do something.
My lord, the lordship is right. But they have already implemented your
Ask
lordship.
him how much fine he will pay. No, it cannot go. It should appear in the newspaper. Otherwise, all people have to spend their valuable time of life in the court corridor, which is not a happy place. We are against that. Ask him whether I should spoil his service records or with the honor he will make payment to the concerned citizen. He cannot play with the lives of the people. You should send him home actually, if not to other home.
My lord.
What these people think of the courts? What is his background? Any disciplinary inquiry was taken at any time in your doing past?
No, he is a very efficient officer.
Efficient. 8 weeks was granted and he was sleeping over the pillow. No, he has to pay 1 lakh rupees. Otherwise, this will not be put to an end. I don't want to please the government. I don't have anything.
No, my lord.
I'm not.
Law is to prevail, my lord. After all, lordship.
I am here to do. I have been sent to this court to do justice to the people.
Obliged, my lord.
Warn them.
Yeah. Yes, sir.
Warn them. Threaten them.
My lord.
Threaten them. what they think about the government job. This is not your fiefdom. Once the court orders, you are bound to comply with the order. Otherwise, you should seek extension of the time, giving explanation as to why it cannot be done within that time.
My lord, time is to be sought for before expiry of that period.
I ask him how much money he will. You are the counsel.
My lord, they have not complied the order of the Honorable Court.
That's what.
My lord, kindly say.
Not kindly see why all discussion happened in your absence. Yeah. Now, he is saying that we have done the order. We have passed the order. What is the order? Let us see the nature of the order, how we have done. Let me see whether there is bona fide or not, or he wants to trouble him and reject it.
No, we are not troubling him. In
Yes,
fact,
give that order. Let me see. That bona fide I will assert. Only because court has threatened him if he passes adverse order.
No.
Then that is another sin. It is another sin. I will not live that way. I don't want to become popular. I am not in the popularity contest.
My lord, here, my lord, your lordship directed to dispose of the representation.
What he has done to the representation?
My lord, he has already passed an order saying the backgrounds of this case. The hairstyle of paper, the Orissa Primary Education Project Authority.
Disturb the court.
My lord.
Rest of the people, they are disturbing.
My lord, I am placing the order what he has passed, my lord.
Where is that?
In Annexure A by 1.
What is the order passed now?
Order was passed, my lord. I have quoted there. He has quoted the order in the above
Rejected.
circumstances. My lord.
Let us see how rejection could have been done. Only to trouble the.
No. We are not.
I
he
will
is
just go through and
My lord.
that is one of
He
the
is not-
factors.
My lord. The project was, OPEPA was presently, OSEPA had invited the expression of interest from NGOs for sanction of granting aid for running non-residential bridge courses centers for the purpose of imparting bridge courses to the out of school children aged between 6 to 14 years of age in an habitation having no primary school within the radius of 1 kilometer from the
What was the prayer?
prayer was, he was praying for some lakhs of rupees.
84 lakh?
84 lakhs.
500.
My lord, I humbly submit that if there is no document to show that the schools are running, that is the problem with us. They have not taken further consent from the government, that from the collector, that the school is continuing. There is no record. And the scheme is closed since long. Huh? No. School is continuing. They are saying the school is continuing, but it is not a fact.
School is not continuing.
Not a school.
School is not.
Scheme is not there.
They have returned from 11.
My lord, scheme is not
They have
there.
returned.
Scheme is not there. Scheme has been
They have-
closed since long.
But the district education officer inquired this matter and submitted a report.
2011
The
Since 2011 the school is closed.
School.
How you will run the school? Only a letter was issued by the collector to open the school, but for opening the school, etc., no document, nothing else is there.
Where is the proof that your school is being done? Which BU attended? Where are your the attendance register? Who are the teachers? How many admissions you have
Sir,
done?
original file again.
This order you have to challenge separately. Now they have passed the order. Let
Yes,
you,
madam.
Mr. G,
My
ask
lord.
him what fine amount he will pay to the, because he has to wage another war now. Because for this he charges that. Every lawyer charges for the case. How much fee you have taken?
3 chapter.
What is the fee you have taken?
No,
I have not received any pie from the.
no. How can you
Then
get?
you will not get any amount from it.
Let's say this.
84,000, 84 lakhs.
All right. He's a disoriented lawyer. Yes, no problem. Now let him pay 10,000 rupees to our which is that
Minus 20,000 or 20,000.
20,000. He is a government employee. Why you are forgetting that?
Should he draw salary?
Yes, he is drawing salary.
Yes. And I will not say more than that. Everybody knows what is what. certain things are obvious. They need not be obviated. Brother, you challenge this order.
My lord.
They have rightly or wrongly, they have passed another. But let him offer an apology.
My lord.
Apology to the litigant, not to the court. Let him offer apology to the litigant. Litigant is aggrieved, not court. I am happy. Let him give in writing. Otherwise, I will mark his service register. Ask him whether he is ready and willing or not. Ask him. If I am not forcing. If he gives this one, otherwise I will pass order. Good case for appeal.
I'm begging on conditional apology
Sir, I am making
Begging.
unconditional apology, sir.
for the delay latches.
I have joined 4 months back. When the matter stood thus, I have taken steps for implementing the order.
How many district education officers are there in the state?
30.
30. You should apologize. You should circulate the apology saying that it happened like this in the court. Therefore, don't give opportunity for such things to happen.
We shall do that.
That
ma'am.
you should do in your WhatsApp groups.
Yes,
All
we
right.
shall do that.
Yes, they should also know.
Yes, yes.
Yeah. The DO, Mr. So-and-so,
Pavitra Kumar.
is present
Pavitra Mohan Barik.
for personal. Learned AGA, Mr. G, appearing for the DO, submits that in terms of the order dated
Order dated 13/8/2025.
13/8/2025, entered in complainant's WP number 22499 of 2025, the representation has been considered and disposed of. Wide order number 2454 dated 2011-2025. First, Mr. G submits that in the fitness of things, the short delay proved in complying with the order of the court to be condoned. First off, in support of that, he support of that, his client, Mr. So-and-so, offers unconditional apology, and hereafter it should not happen.
No. Yes.
And undertakes that hereafter no such lapse would happen from his side. First off. He also undertakes before the court that he would circulate the ire of this court amongst his colleagues, so that they also would not commit any lapse in complying with the court orders. First off, in the above circumstances, these proceedings are dropped, reserving liberty to the complainant to lay a challenge to the subject order dated 2011-2025 if he is so advised. All contentions kept over. Disposed of.
Highly obliged.
Yes. Yeah.
Yesterday's matter which was closed, point of that word should not be courteous. Just
What should not be?
Words should be interpreted and this is a.
Yeah, I got that. Justice Vivian Bose's judgment, 53 Supreme Court. 1953 Supreme Court.
Should not be dead later, should not be courteous.
What use?
Yes, but
Just but I think judgment is already we have. No, we have a Yes. Yes.
Item 1. May I please, my lord? The case is that the petitioner challenged annexure 11, rejecting his prayer for grant of the scale up for Group B employee. I was appointed as a live attendant. Annexure 5, the notification of notification by G Department page 24, and it's page 24, madam.
8/8/2012.
My lord,
That the resolution.
resolution that the group, the rules may be called Odisha Library Attendance Service Group C. It's a Group C post, but I have served regularly in Group D post, for which we approached the authority earlier. Annexure 6 issued a finance department that is page 28, my lord. They are giving the benefit, but not prospectively from that date. I myself regularly from 13, my lord. They are giving the benefit from 2019. I earlier approached, my lord. My lord directed, once rejected the case, again my lord directed under annexure.
You take notice, Mr. Mr.
Only reverse
He is
the product.
requested to accept notice for notice. Yes.
Item 2.
May I please?
Yeah.
Petitioner's claim for placement of has been rejected under Annexure 6 manner.
Placement means?
Placement to the post of lecturer group A and the reader. It is provided that the lecturers shall be placed in the lecturers group A after 8 years of getting
Service.
nothing.
That UGC guidelines.
No, it is
State guidelines.
prescribed. And reader scale after 10 years. But no, this claim has been rejected. It is the
They
second.
don't have rejected.
Most similar to
Yes, similar.
Loknath Chaudhary case you want.
And Loknath Behra.
Loknath there.
Similar, in similar cases, your lords, you have been pleased to issue notice.
Issue notice.
Man.
Same order. All along. Yes.
Oh, please.
Item 3.
May I please, your lordship? Lords, on 1/7/2014, the petitioner was joined on ad hoc basis as a lecturer in psychology in Gangadhar Mehra University, my lords. Thereafter, this ad hoc appointment was extended. Subsequently, my lord, on 8/7/2016, this appointment was withdrawn and a fresh appointment was given. A coordinate bench of this honorable court has been held. The similar issue has been challenged by the other candidates, my lords. That is at page 28, my lords. I have given the judgment, my lords, where this honorable court has been pleased to direct the authorities to pay the differential amount for the period. And in the year 2019, again, I was appointed as assistant professor in GM University.
Take notice, sir.
Yes.
But representation is pending.
Consider representation.
That judgment, lordship, kindly see page 21, lordship.
No, I'm asking you.
Yes,
You
lordship.
will be happy.
In that, in the light of this judgment, my lords, I have
The
quoted.
right of your representation is page 21, Annexure 5 series.
Series and judgment is at page 28, lordship. Exactly the same issue, my lords, same appointment. Two judgments I have referred before, lordship, page 28 and 39.
WPC,
My lords, WPC,
reported judgment.
WPC OSC 1011. Page 28, lordship, kindly.
10
of 2017. Page 28.
decided on
Decided on 19/12/2023.
It's an order, not just.
Sorry, order, lords. I'm sorry. My representation is also to consider in this, my lord. Page 3 and 5 of the paragraph of the writ petition I have quoted, lords.
Okay. Petition prayer reads as that. First, in support of the prayer, learned counsel appearing for the petitioner draws attention of the court to a coordinate bench decision in WPC OAC number 1011 of 2017 between Shrabani Mishra
Lords.
versus
Shrabani.
Odisha. Disposed of on 19/12/2023. First one. He also draws attention of the court to his client's representation dated
Lords, 8/9/2025. Page 22.
2025. The copies whereof are at Annexure 5 series in that connection. First one, counsel submits that. If the subject representation is considered in the light of coordinate bench decision, his client will be satisfied. First off, with this proposal, Mr. Lenka, learned AG, is also is agreeable, subject to the condition that all contention should be kept open and a reasonable period be prescribed for disposal of the representation. Is first in the above circumstance. 6 weeks. All contentions kept open to solicit, web copy to be acted upon.
Grateful, lords.
Next.
Item 4.
Lordship, I am for the petitioner. Lordship, 1 week adjournment as per the
They're
instruction.
not audible.
As per the instruction of my senior, 1 week adjournment required.
1 week. Let's say why I will assist you. What is the matter about?
Matter is, my lord, that BMC on 13/6/22 sent a notice to the petitioner to demolish the construction, stating the reason that I am not complied with the section 15 of the ODA Act 1962.
Appeal also is dismissed.
Yes, appeal.
Appeal has been rejected by the annexation 9,
Yes.
page 48.
Lordship,
But they have asked
this
you
is
to demolish the building.
Yes.
Lordship,
Matter requires consultation. So demolition is a serious matter.
Actually, issue notice that
Order.
the BMC.
Lordship, there is an interim protection. Lordship.
Heard Shri. So and so. What's your name?
Ajit Sahu.
Heard Shri Dixit SAHOO appealing for the petitioner who argued well. First one, he submits that there are arguable points in the matter and therefore it requires a deeper examination. First one. This appears to be written. Next paragraph. Mr. SAHOO draws attention of the court to application in IA number 19656 of 2025, supported by the affidavit, wherein they are sought for interim protection against the demolition. First, right to residence is constitutionally guaranteed under 19. Take that. So and so. And demolishing a structure, existing structure, is a serious affair. First, if a structure is demolished, the petition itself may be rendered infructuous, which is not a happy thing to happen in the portals of the Constitutional Court. First, no prejudice should be caused to anyone if status quo is granted during the pendency of the petition, as rightly submitted by Mr. SAHOO. First, in the above circumstances, subject application having been favored, parties are directed to maintain status quo during the pendency of the petition application.
Party 2 and 3.
Huh?
Party 2 and 3. Notice to be sent because BMC.
For one, emergent notice for 2 and 3. Next.
Item 5.
My lord, in the petitioner is a person who is occupying a land of the Lord Mahaprabhu Lord Jagannath, which has been recorded in the one mort. As per he has given a representation to the temple administration to consider his representation, and
Whose land it is?
land is of Mahaprabhu Lord Jagannath. That is running page 11.
Why it should be recorded in your name?
I am occupying since a long.
If you occupy some government land, it
There
should
is
be granted to you.
No, there is a temple administration is settling the land in favor of the persons who are in occupation of this land.
So where is that? Show. Which law?
That is not with me, but there is a distance.
No, it's a temple land. I have to have the wrath of Lord Jagannath Mahaprabhu if I agree with you. You know, show the law, I will do that.
Let it come on a chapter, I will find out.
Why your petition? You are seeking time without coming preparation. Which law gives you such a right?
There is a temple, there is a judgment of all this also. I have not annexed, I will go through that.
At the request of Gonsalves, the petitioner, call this matter after 4 weeks to enable him to come with more preparation. Yes.
Item 6.
May I plead your lordship?
Yeah.
That is anticipated regularization of class for employee.
Covered by judgment.
No, your
Not
lordship.
covered.
No, only your lordship to issue notice, and university panel council is where I.
Any order is passed now.
No, madam.
But let them consider the application.
No, your lordship, fact is different. Earlier, I approached this honorable court. This honorable court has allowed my prayer for regularization. Then university approached SLP before this Supreme Court. That was dismissed. During pendency of that case, then I was given retirement. Now question is, when I have already been given retirement, so question of regularization does not arise. For that, my prayer is, until unless antedated regularization order is not passed, so I will not wait. That is my prayer.
Take notice then. Issue emergent notice. ASC Mr. Sen is requested to accept notice for 1 Not one.
I am for
Four.
3 and 4.
Four. 3 and 4.
One and two, my friend.
Mr. S.C. Ratha.
Yes, see, S.C. Ratha, Canal Council accepts notice for 1 and 2. Yes.
Item 7.
May it please, your lords.
Yes, the present may be filed within 4 weeks, failing which petition may be treated on its face value for everything out of this.
May I please, your lords. The present prisoner is working as the guest faculty in DD University. During his continuance, another advertisement issued for engagement of guest faculty. It is covered by your lordship's order, similar petitions.
Is it covered by the judgment? Do you have issued the copy?
Order your lordship had issued notice and interim
Order.
order. Yes, my lord, interim order.
Counsel for the petitioner submits that in identical matter, namely WPC number 31880 of 2025, notice has been ordered and interim protection is also granted. And therefore, is the client's case being similar to the one comma, the same order needs to be issued. First, there is force in these submissions. Next, issue emergent notice. Learned DG is requested to accept notice for 1, emergent notice to 2, interim order as in WPC 31880 of 2025.
Second
All
matter,
along with
second matter is similar.
same. All
Yes.
in.
Published.
Same.
Item 8. Item 8.
May I please, your lordship.
What is this letter?
Petitioner is a minor.
Ah.
They are aggrieved by this letter under Annexure 4. Your lordship, central government has issued a scheme of scholarship that is named as National Means Cum Merit Scholarship Scheme. Your lordship, that is at Annexure 1. It was implemented for the Annexure 1, your lordship.
Yes.
It is the noble cause of this scheme is to, your lordship, to award scholarship to the meritorious student of economical weak section to arrest their drop out at class 8 and encourage them to continue study at secondary stage, your lordship.
Yes.
So for this very purpose, this scheme has been introduced that
Now what happened?
now what happened, your lordship? Now the state government has issued the scholarship for the year 2026, 25 and 26. That is under Annexure 2, your lordship. I have applied for the same online. I have applied for the petitioner has applied for the same online and his application is at Annexure 3.
What happened to that?
Subsequently, they have rejected the scheme. They have stated that because the present school of the petitioner is a residential school, so the examination will be not held and he will be not eligible to appear in that scholarship exam. But your lordship, the present school of the petitioner is not a residential school.
Not a residential school.
Not residential school. And prior to this, your lordship, I've also annexed
How they came to the conclusion that it's
your
a
lordship.
residential school?
There is another letter from central government which they have reflected, they have mentioned also, and that letter is.
Notice.
In that letter, your lordship, at Annexure 5, your lordship may kindly see.
No, take notice.
Your lordship, the examination schedule is going to be your lordship
When?
kindly see page 21.
When
page-
the examination?
they will get the download admit card from 3/12/2025 to 7/12/2025, and the date of examination is fixed to 7/12/2025. So a student who is appearing in this exam is with
Issue emergent notice. Learned DSG, Mr. Pari is requested to accept notice for 1 emergent notice.
to is the two,
234.
Your Lordship. One,
234 ASC. Yes. You appear for one.
My lord, one Union of India.
So it appears for Union of India.
I pray, Your Lordship, my IA may be considered.
An application IA number 20743.
Your Lordship.
My lord, will take instruction. Your lordship may
What instruction? Let the candidate appear for the examination subject to outcome of the petition. Then
Your
it will
Lordship.
lose. What will happen? On the other hand, if he is not permitted, 1 year may be lost.
Admit card is given to me.
Very student, Your Lordship. I have also annexed the mark sheet. He has secured 95%, whereas the eligible mark is 55%.
What was your percentage in the same point? Your percentage in law?
It was, I think, 58 point or 68 around that.
You have argued well with. Heard
Right.
Learned Counsel Srimati so. Miss or Mrs.? Srimati. Married.
Oh, Your Lordship.
Srimati so for the petitioner. A case is made out for issuance of emergent notice and also interim protection, so that student could take the examination in the office without pleading any equity. Then it pleading any equity subject to outcome of the petition. First, Sri so and so is requested the notice for number 1. ASC Mr. Sen is requested to accept notice for 2, 3, and 4. First, in terms of application in IA number so and so, supported by the affidavit, petitioner is permitted to take up the examination in question, which is in the office. First, however, result of the examination shall not be announced without leave of the court. First, no equity shall be pleaded by the petitioner on the basis of this interim order. Okay.
Yes, Your Lordship.
Jurisdictional authorities to do all that is necessary to facilitate the examination being taken by the petitioner. Okay. If interim order is not complied with, the defense of the other side may be struck off.
Item 9.
May I please, Your Lordship?
Yes.
The petitioner has been transferred in violation of the government guidelines. Answer 1 is
1311.
minus.
1311-25 transfer order.
Minus.
How many kilometers?
The guidelines says, my lords,
How many kilometers?
kilometers, 30 kilometers, just 30 kilometers.
kilometers.
But there is a mountain, he has to cross the mountain.
Mountain like Hanuman. Which mountain? Which
School is
Mount Titlis or Himalayan mountain?
School is situated. School is situated, and the new school is situated.
You will issue notice that you join the school.
Other side of the mountain.
Nothing happens. You will have good
And
exercise.
And my
Right.
lordship is the government guidelines matters.
Yes.
He is a assistant teacher, ex-cadre teacher. But he has not to be transferred. That is their own guidelines matters.
Let us see.
And he has also made a representative.
Now relieved.
No. Yeah.
Not yet relieved.
No.
Consider the representation.
Yes, madam. He has been deployed valid only for
For a period of.
can be revoked at any time, my lord. Lordship kindly see the.
No, means any time means any time. It's Stephen Hawking's the history of time.
For administrative exigency, he has been deployed.
Huh?
Yeah, only for administrative exigency, he has been deployed, man.
You will use that term.
And he has
every
continued
case.
from the initial appointment, he continued in the same place, man.
Where?
The present place of posting, man.
How long he has been there?
From the initial appointment, man.
How long?
That is.
When were you appointed to
He was
that?
appointed in 2008, my lords.
2008. Permanently
Became
what took time
regular
there?
ex-cadre teacher matters or became regular in
You
2018.
consider representation.
Lordship.
The essential grievance of the petitioner is against non-consideration of his representation dated 14/11/2025, wherein he has erred, he or she, he has erred some grievance against the transfer order dated 13/11/2025 on the basis of the extent transfer guidelines promulgated by the state. First, the counsel for the petitioner submits, and the ASC very graciously agrees that the subject representation shall meet its fate within a reasonable time in accordance with law if all contentions are kept open. First. Next one. Ordered accordingly and writ petition is disposed of. Till consideration takes place, petitioner shall be continued in the same place.
Item 10.
Item 10, may I please, Your Lordship, the petitioner had made a proposal to the government for establishing a school for the autistic children. Lordship, that proposal is at Annexure 2, page 45.
For allotment of 6 crore.
6 acre of land.
Who are you?
I'm the trust who is already running a particular school in that particular locality. There's an adjacent vacant government land. IDCO, Odisha Industrial Infrastructure Authority, is the authority who allots land on basis of availability, suitability, Your Lordship.
Where is the policy?
Your Lordship, that there is.
What is your right? You are already running the institution.
I have made a proposal, Your Lordship. I have made a proposal, which is on basis of proposal. All the proposal is scrutinized by the high level. There is a high level committee. They will scrutinize all the proposal and accordingly act upon it, Your Lordship. There is the committee. I page 47. If Your Lordship see.
So take notice. I will not pass order. Take
Lordship, what has happened in the meantime? The high level committee in April 29, they said the specific particular land which I had proposed to Your Lordship, that they are going to allot it to some other institution they have planned. Irrespective, knowing that there is a proposal from my end is pending before them. That Your Lordship may see for just a moment, Your Lordship may see that committee, Your Lordship, Annexure 4 series, Your Lordship.
Issue emergent notice. ASC is requested to accept notice for 1 and 2. Emergent notice to 3. Any allotment will be subject to outcome of the petition.
Lordship.
Next.
Item 11.
Any allotment of the site shall be subject to outcome of the petition.
Lord, I beg to apply, my Lord. Before filing this writ application, I need to verify the documents. So,
what is this matter about?
My Lord, this application, my Lord, the petitioner as well as the parents of the student made an application before the collector as well as the
to hold inquiry on the ground of corruption, etc.
etc. My Lord.
What is your source? I asked. Therefore, I said 1 lakh rupees cost I want. That is the order. 1911-25. Otherwise, all unscrupulous people will come before the court, and we will be spending our time on the unscrupulous cases, which otherwise would have been used for good cases. Give 1 lakh rupees. This court wide order dated 1911-25.
My Lord, I beg to pardon, my Lord. My Lord, regarding the cost, impose of cost, my Lord, kindly consider, my Lord, because it is my mistake, my Lord, before receiving this brief, my Lord. I need to verify that document.
You went to his house and you asked him, give me a case, I want to prepare a case and file. No, he came to you.
My Lord, no, my Lord.
You went to his house.
My Lord, because the petitioner is also an advocate and practicing in Tahsil office, sorry, my Lord, Kendrapada court, my Lord. So,
Matter having been heard, is permitted to be withdrawn. Reluctantly, not levying costs for abusing the process of court. Custom. Ordered accordingly and petition is disposed of. Registry to send a copy of this order to who are the opposite parties?
my Lord, opposite parties are the
OP numbers, headmaster,
my Lord, 7 is the headmaster.
5 and 6. 6, 7 by speed post. Okay,
My Lord, Mobilize.
for their fight. Next.
Item 12.
Item 12 is that case, my lord. Your Lordship, last occasion, directed to get the datas of the schools where the vacancies are lying. Today I am having all the datas, but it is not a proper format. So it may vary. My lordship may give me a week's time or 2 to 3 days time. I will file that.
Call on
Any date you lordship.
Friday.
Next Friday. Yes.
Friday. At the request of Mr. Learned AG.
So for
Steps and other things have to be stated. What you
Yes. I will go. I'm collecting the case numbers where it is, who are pending, and the interim orders are also. Yes, my lord.
There are no interim
order.
The recruitment process should begin.
Highly obliged.
so for connected writ application, lordship, it takes first time last occasion listed and a lordship tag it to the present writ application. The writ application involved in the my Lawrence senior client lordship, that is so far the school and university is concerned. The my writ application lordship here the applicants paying for colleges lordship, aided colleges. So
there also we are having instructions.
Yes.
Your lordship has taken note of.
Matter notice is issued.
No, my lord. The first time listed.
Which is that?
That is WPC 31585 of 2025, my lordship.
Yes. Issue emergent notice. Mr. G. Learned AG requested to go to the constable. Requested to accept notice for
both my lord senior
copies. Okay. Call along with
along with lordship, the interim application I have filed lordship.
Yes, next.
Item 13.
Is over, no? This is 13. 13.
13.
Serial number?
12 wheelers connected item to 12.
3151.
Yes, 13. Yes, sir.
I have filed a petition for modification of the order dated 11/11/2025, which has been passed by your lordship. My lord, I am the individual person which has been affected by the order.
Letter was there on
11/11/2025.
Your lordship directed since a matter
Necessary set of papers are filed.
PIF.
It's because I am only the person who has been affected by the fish market.
Which order you are challenging?
My lord,
Which is the order you are? What is your prayer?
my lord, I want to modify the order dated 11/11/2025. 11/11/25.
What is that? 16/10/25?
My lord, the order passed by the council on 16/10/2025.
What does it say?
That he has changed the fish market to before in front of my house.
He has shifted
the
in
fish
front of the
market
house.
in front of my house, so that I have been affected by that fish market and also a chicken market. The area
Your client is not a non-vegetarian. Whether your client is a non-vegetarian.
that the area is polluted, so that I have been affected.
Take notice. This court-wide order dated so and so had said as and done. Order is there. Look into it. Counsel for the petitioner submits that the matter lies in the portals of this court by virtue of Chief Justice's roster order. He is raising a grievance as to nuisance on account of the fish market and mutton market being shifted to a place beside his house. First, issue emergent notice. Mr. G is requested to accept notice for 1, 2, 3. All. Yes.
Item 40.
Yeah, Mr. Chula.
I am appearing for the opposition to 2 and 3 Berhampur University.
What is the case about?
The case is
Minutes, I seek an adjournment minutes.
Yeah.
I am on behalf of the petitioner, Mr. Gauriman, I am seeking an adjournment in this one.
Not audible.
Minutes, I am
Some of the lawyers and judges should be humble and meek, but not weak.
I am seeking an adjournment.
Adjournment.
Yes,
Yes.
may
Second week.
pray in the similar for the recovery during the pendency of this writ petition, another petition has been filed by the petitioner. I pray that this petition may be back to that petition.
No. Call along with the
Mal.
WP number. So. Okay. Take the second week of January.
Item 15.
Item 15, my lords, I pray for an adjournment on behalf of my learned senior.
Same order.
My lord, this matter has already been in process. My lord, kindly see this notification.
What is your prayer?
My lord, supersession of the governing body. That order was challenged before this honorable court. This honorable court granting stay. 2023, this matter was listed. My lord, kindly see the order dated
8/12/2023.
18/11/23.
Yes, my lord.
It is for 2 years.
2 years.
Yes, matter has become inflection.
Lordship, I have to take instance.
No. You need not take any.
Your lordship, but the body was initially.
The petition prayer reads as at by virtue of eclipse of time, efflux of time, EFLUX, comma, petition has been rendered infructuous. First, and accordingly it is disposed of. Yeah. Reserving liberty to the petitioner to challenge other causes of other work out here other grievances on the basis of fresh cause of action. Okay.
Who made it?
Both.
Item 16.
Item 16, I am for opinion number 5 in both the cases. I am for opinion 5 in both the cases. I have been informed that the petitioner's counsel's father is hospitalized. So therefore, your lordship may
In the
take this
second week of January 2025.
in the month of December, your lordship may say.
December we have difficulty.
It is urgent in nature because regarding the
Okay.
December, my lord posted it.
No. Next.
Your lordship may put it December.
I have said that. Next.
Item 17. Item 17.
Yeah.
Just ignore counsel. Actually, this case.
17. You are for OP. You are for petitioner.
In this case also, senior counsel after this case
Caste matter.
This was caste certificate.
The caste certificate, Madhuri Patil's decision is there, also know, but they have filed a counter. So can I just file a rejoinder to bring the Supreme Court decision also on record? Supreme Court decision, a recent Supreme Court decision, which has given the liberty to, this question can be raised here before this High Court.
Is it?
I'll file it.
Justice B.S. Chauhan's judgment? No.
No, it is not.
Anyway, just not. Calling the whether earlier VV is loosened now.
Say, this is another matter arising out of this matter. Connection with the election dispute. last paragraph, if your lordship looks at.
Any election related matter?
Yes, the previous election.
Previous election.
Right. Now, this is the current election where the lordship have said the question can be adjudicated.
By this court.
Right.
But not in EP. In the Chandra versus so and so,
Yes.
the three-judge bench of the apex court said, where in respect of an election for a reserved constituency,
Right.
if the issue as to the social status arises, that should be decided by the election tribunal.
Right.
But
Here
why
it is
Here-
decided.
Huh?
No.
Here in this
They
case,
decided.
it was decided by the election.
tribunal? Yes.
That's it.
In the second week of January 2026 at the request of services. Item 18. Yes.
Here, my lord, the limited grievance of the petitioner was engaged as a Ganashikyak on 24 of May 2008.
Scale of pay.
My lord, what has happened, my lord? Petitioner was engaged as a Ganashikyak in May 2008, 24 of 5, 2008.
Lordship,
You have made-
notice was issued. In some of the cases, we have filed counter. Here, if you will give me the list of cases, we shall adopt that.
I have not received any counter fight. My senior is.
So in other matters, he might have
We have filed counter from the government. Government.
You take notice.
Notice are already issued.
Notice is already taken.
Yes.
Which are the other matters, connected matters? Give list.
Yes, it is not there in the list on today. In many cases, your lordship also issue notices, and he has also so many cases. If you
You have
look at
other
the
lists
list,
also?
yes.
Other cases where my lord have issued notice. No counter. I have.
No, it's all right. Which are those cases?
I'll give
Give the list. Call this matter.
only one point is consideration. Short
The-
point.
The second week of December 2020, along with other connected matters. Yes, give the list. Yes, next.
Item 19.
My lord, I am for the petitioner. Lord, I pray for some time to file a rejoinder affidavit, my lord. Because
Call it the second week of January 2026 at the request of so and so, who intends to file rejoinder.
not the interim order is
Interim order is there.
interim order is there. That is filed an IA for vacation. The Lord had heard him. And had given opportunity to my learned friend to be prepared and had wanted instructions to be brought on record regarding location of CNG stations in the manner which is being.
I have obtained all the information, but I have to file a rejoinder.
And the matter is
placing everything on record.
Some matter is pending before the learned NGT.
It is on a different context altogether, Mother.
All right, in the second week of January. Earlier we have difficulty, brother. Yes.
Interim order is to be
Interim order to continue till next date of hearing. Yes.
My lord, I am for the pollution control board, my lord.
Huh?
Your lordship, just one thing I'd like to draw your attention, your lordship. In this case, your lordship, Bhopal police case, your lordship, specifically the apex court has said, so once it is coming within the ambit of the NGT, in schedule 1, it should be transferred to that.
Let us see.
Item 20.
Please, Your Lord. My Lord and Senior was appearing yesterday, my Lord, and filed the memo of appearance.
Memo of appearance?
Yes.
For OP?
No, my Lord, for petitioner.
Petitioner?
Yes.
Argue?
No, my Lord. Pray for 1 week time.
For filing objection to the OP? What is that? You are saying you are not clear.
My Lord, my Lord.
You appear for whom?
Petitioner.
Petitioner?
Yes, ma'am.
You are Suresh Prasad Dash. Who are you? What's your name? Your name also you want to check?
Okula, sir.
What is the name of the petitioner?
Petitioner, ma'am.
What's your name?
Ma'am, my name is Satyajit Paltesan.
You want to file power?
No, my lord. My lord and senior is filing the memo of appearance, Samir Kumar Mishra.
Senior advocate appears in this
Yes,
matter. You want time?
Yes.
Second week of January.
Item 21.
I am permitted to plead on behalf of Mrs. Jaina, ma'am. My lord, the petitioner is challenging annexure 8 rejection order, ma'am.
My lord, grant us Passover.
All right. Third week of January. At the request of. Next.
Item 22. May I please, Your Honor? This matter relates to grant of pension. The petitioner has retired from service since 31/3/2000.
G, ready in the matter?
No, my lord, no comment.
Here, my lord, I have no grievance against the state. The state virtually is supporting me. My lord, I have grievance against the controller of
Your
accounts.
Lordship, last occasion directed to obtain instruction in the matter from the controller of accounts. Controller of accounts has also sent us an instruction. Lordship. ମୋ ପାଖରେ କପି ନାହିଁ ତ ସେଥିପାଇଁ
କିଛି ଦେଖେଇଦେବି। The pension sanctioning authority, who is the district education officer,
my lord,
he has sanctioned the pension. But the controller of accounts raised certain objections. Those objections were complied with.
Yes.
Twice I have approached this honorable court.
Yes.
This honorable court directed for consideration of my case. Now again he is making same objection.
They are saying
And
that
because of that I am only getting provisional pension,
they are saying that
no regular
in the-
pension, no retirement benefit.
Accepted. In the instant case, the DEO Baleshwar has transmitted proposal for authorization of final pension and final gratuity in favor of the petitioner by this letter number so and so to this office in compliance to this office objection number dated so and so. But on verification of proposal dated 16/1/2025 of OP3, the OP number 4 found that the pension sanctioning authority has submitted proposal without proper compliance to the letter dated 27/2024 of this office. Thus, the same was again objected by this office letter number 9/4/2025.
But I failed to understand.
Let him complete this. Yeah.
Return to the opposite party number 3 for resubmission after proper compliance, but no compliance has so far been received in this office from DEO Baleshwar in response to the letter dated 9/4/2025 and letter dated 16/7/2025. Soon after receipt of the compliance from the pension sanctioning authority, the DEO Baleshwar, the controller of accounts Odisha shall take expeditious steps for authorization of pensionary benefits in favor of the petitioner if the same is found in order with pension rules and in force.
Why DEO is keeping quiet? Ask him to be present before the court.
My lord, will your lordship?
It was sent in April.
Yes.
He has complied.
We are in November, end of November.
Well, DO has complied. Well, Your Lordship, may kindly see my additional affidavit. On 29/2025, he has complied and compliance report has been filed. I have given that.
Ask both the controller of accounts
Well, the controller of
to be
accounts is-
present before the court. Both should be present before the court. We are not here for doing tamasha. Ask them to be present before the court. Both the intra-departmental dispute is as to the compliance of pension papers. First one. The controller of accounts makes allegation against the DEO, whereas the DEO says that he has complied with the requirement. Yes. First, in view of the above, both the DEO and the controller of accounts shall be personally present before the court. When tomorrow, day after tomorrow?
No, my-
Monday, Tuesday.
Sometimes in the next week, my lord.
On 24, 25 or 26 will you?
No, my lord.
Let them come on 28th.
28, 11, 2025. 20. First. If they do not come up, they run the risk of arrest and detention at the hands of police. First. However, presence shall not be necessary if in the meanwhile all compliances are reported and positive steps are taken in the matter in accordance with law. First, a copy of this order, a carbon copy of this order to be made available to the learned HE asked. Generally, I do not call officers to the court. But now in this court, unless we call, nothing will move.
No, Lordship is right.
Yes.
Item 23.
My Lord,
Yeah.
on the behalf of S. Palik, this matter taken up to 1st December. He is out of station.
Difficult matter. Tell me what are the facts of the case. I am not going to pass any order. This is a precondition for seeking adjournment. What are the facts? Facts of the case. Tell few facts of the case. Otherwise, you will be coming from the market and ask the adjournment. I will not give for market people. You should tell few facts of the case. Then I'll consider your request for adjournment. What's your name?
Wasit Khan.
How many years of practice you have put in?
2 years.
2 years. But you should be able to tell, brother, by now. Next time we will do that.
Yes.
Call this matter in the second week of service, so at the request of.
Sir, my Lord, counter has been filed.
Yes.
Item 24.
May I please?
Yeah.
I am for the petitioner.
Counter.
But sir, if counter ballot will be required, then my case may be disposed of because the Borumbar University has already given consent to the proposal to the government. It is pending since 2012. That has not been considered. My only grievance is that will be considered. So I am submitting, madam.
File counter. But my
permission has been given.
How can you say that? He's opponent. He is right to file objections.
No, he has already given permission to the seeking.
He may say permission is withdrawn.
No, sir.
We do not.
You
Sir, can you preempt right to file objections?
No, I am not saying to file objection. Kindly see the order dated. My Lord.
Third week of
Next 3 Saturday. Kindly peruse Annex 3.
Next. Third week of January 26. Yes.
Item 25.
In the meanwhile, counters, if any, may be filed. Okay.
Is like that concerning the bench amendments, concerning the engagement of appointment and engagement of the junior teachers. Pursuant to the resolution dated under Annex 2, my Lord, the petitioner has applied for the post of junior teacher in respect of.
There is no objections are filed yet.
No, Your Honor, objection has not been filed. This is a matter, it is all the way similar of the yesterday matter that up to HSC that MIL qualification like this because the petitioner belongs to that Telugu. The MIL is Telugu.
Okay.
The junior teacher appointment.
Where is your certificate? BSc certificate?
Graduation, Annex 1 series, my Lord,
Annex 1?
Yes, 1 series. He has qualified the secondary school certificate from Andhra.
Secondary school certificate means
HSC.
HSC is 10th standard.
Yes, madam. Yes, from Andhra. Because the present petitioners, they are residing in the bordering states of Andhra and Orissa, madam. So, because they belong to Telugu caste and Telugu community, the facility of education in Telugu is not available in our state, madam.
Okay.
So they are bound to go to to take their education. They are bound to go to Andhra Pradesh.
They went
on one hand, yes, man. On one hand, the government is not supplying the infrastructure for Telugu people. On the other hand, when they are coming to selection, they are objecting for such selection, man. That to my lord.
What is the requirement?
Requirement, my lord, that is
page 45.
You will also make that plus Annex 2. Lord's page 45. Annex 2. Page 46 में you are also method. Page 46.
Read relevant portion.
Yes, my lord. Clause C, my lord. Can I read, my lord? Candidates must have ODIA as ML up to class 10 or pass in ODIA language test equivalent to matric standard conducted or declared equivalent by Board of Secondary Education, Orissa, except for the candidates as mentioned under para 5.2. Then we will also meet on to 5.2. In order to be eligible for Urdu, Bengal, Telugu junior teacher schematic, candidates must have passed Urdu, Bengali, Telugu, as the case may be, as ML up to high school certificate standard. Since their engagement is likely to be held in the bilingual schools, such candidates shall produce a certificate from the headmaster of the concerned school to the effect that he or she has passed HS examination in ODI medium.
Have you passed it HSC?
Yes, HSC Johnson in Andhra Pradesh, Miller. That is not the ODI medium, Miller.
In Telugu?
Yes, Miller, in Telugu. That is admitted, Miller. But because of this clause C, Miller, if one candidate will has qualified the ODI language test, that is declared equivalent by the Board of Secondary Education, Odisha, except then the present petitioner has qualified that test, Miller.
What is this case about correctly? I'm not understanding. He has passed the Telugu examination in equivalent to HSC. Then what is the problem?
Problem says, my lord, they saying that you have to produce a certificate from the headmaster that you have passed you have qualified the examination in ODI. In one hand, they are giving the
vernacular it is required, which has been specially contemplated in point 5.2.
That he does not have.
Yes.
He does not have.
No.
You do not have ODI.
ODI that I have qualified the ODI as a single subject examination, my lord. I have qualified.
5.2 for a moment.
I have placed before Lord. So, but the other candidates, my lord, in Gondam district, they have given. NSF 12 series. Yes, my lord, NSF 12 series.
Have you given employment to other candidates?
Yes, NSF 12 series.
So far the other candidate that I have to take instruction, but so far the 5.2 is concerned.
No, after seeing 5.2 only, if you have given employment to others?
Others is definitely.
Verify and give it next week. We'll have
take instruction. So far the other party is concerned.
Counsel for the petitioner submits that similarly situate candidates are already given employment, whereas he is discriminated against. First, learned AGA Mr. Mohanty to procure information in this regard. First of all this matter in the second week of December.
One thing, my lord, may draw your lordship's kind attention to Annex 13.
Let him come.
Yes,
say this.
Yes, problem. Deeply.
Item 24. Last part one item 25. Last part one is different back to madam, not the similar.
Last but one is different.
Double from 5 to 8.
Separated. WPC. Which one? Double 2, 3.
5 to 8.
Double 2, 5 to 8.
Transfer matter, biography 20.
We did that. Double 2, 5, 3, 8.
5 to 8, madam.
5 to 8.
Yes. Double 2, 5 to 8.
Second. Did take it.
And similar matter is 24 transfer matter. That's American.
Double 2, 5 to 8 of 2025. So we did take it. Yes. When these transfer matters are put.
24th madam.
All these matters on 24 along with other connected matters. Order to ban. Next. Item 26. $2252 is mistake, no? Then detail. Yeah, that will put in December 30. Yeah. Item 26. 22.
Sir, I am the petitioner in this case, my lord. I'll understand it.
I am the
I'll ask you to intervene. I'll ask you to intervene. Do not allow field.
Then what is this matter about?
Matter, my lord. BMC pass an order, my lord. BMC OP number 2, my lord.
BMC?
Yes, my lord.
What is that BMC?
Bhubaneswar Municipality Corporation. Pass an order to demolish the second and third floor of the building of the petitioner. Which
On
was
the ground?
Ground, which was unauthorized release.
The background of the case is like this.
Will come to you also. So you are complainant.
I am the complainant.
You are the
I am the widow of his younger brother. I am the widow of his younger brother. So, and he has erected a huge building on the boundary line so that my entire building is shadowed. And I am suffering from injurious affection from my neighbors.
Yes, my lord. The daughter-in-law, he tried to demolish the building of the father-in-law, my lord.
All right. But you built it without permission?
No, my lord. This is
Show that.
This is covered under the judgment of our own High Court, my lord. The point always involved. BMC has no power to pass an order under 91 of ODA Act, my lord.
Who should pass the order?
The honorable court, madam.
Well, that is
our own High Court, madam.
that case we have examined. That is in the case of Raulkela Municipal Development Authority, but for Kotak and Bhubaneswar that is different. So that judgment which is not applicable in this, he has relied upon.
Under which act?
ODA Act, my lord. Order was passed under ODA Act, my lord. BMC, Bhubaneswar Municipality. Odisha Development.
Odisha Development Authority Act of 1982.
ODA Act. ODA Act. Who has power to demolish?
BMC under Municipality Act, my lord. BMC has power under Municipality Act, my lord. Not under ODA Act, my lord. It passed under 91 ODA Act, my lord.
Under which section it is passed?
91 of ODA Act.
Read. Then appeal is to 91, 92.
92.
Why you have come here?
Yes, my lord. I have prefer appeal, my lord. Appeal was dismissed. Against the appeal, my lord,
you have come here.
Yes.
91 order. Can you read 91?
Yes. Removal of unauthorized development, where any development has been commenced or is being carried on or has been completed in contravention of the development plan without the permission, approval or sanction referred to in section 15 of contravention of any condition, subject to which such permission, approval or sanction has been granted, or any development deemed to be a development undertaken, carried out or completed without a permission as referred to in section 15 under clause B1 of section 2 of the section 1 to 8. Any officer of the authority empowered by it in.
Who is the authority?
Authority, my lord. Here, my lord, BMC passed the order, my lord. ODA, only development authority has authority development. Odisha officer under ODA, my lord.
Whether authority is defined?
Yes, my lord.
What is that?
Authority, my lord.
Under executive instruction.
Authority 2-4.
Yes, my lord.
Means a development authority.
Development authority.
This act.
Yes, my lord.
Yes, it has power.
Here, my lord, passed Bhubaneswar Municipality Corporation, my lord.
Municipality has order.
Yes, my lord.
Take out Municipalities Act. Municipality is constituted under which act?
Odisha Municipality Act, my lord.
Take out the act.
May I clarify this?
Shall not we read? I am from outside. I should read the law. Then I should hear you.
Lord, you can see my best party of my.
I'm not saying anything. Go to Municipalities Act. Whether they have power to pass such order or not. Let us see. Once the land is developed,
yes,
then it goes to the municipal body.
Yes, ma'am.
Which is that section in generally in Karnataka, there is such a provision. Under this section, when the layout will go to the jurisdiction of the municipality.
That's after constitutional amendment, my lord. Can you see
Just kindly see, my lord. Page 40, my lord. My page 40, my lord.
Your page 40.
Yes, my lord.
That is what you have stated.
The judgment of this honorable court, para 14, my lord. As you will see, just.
There is already a decision taken.
Yes, my lord. Yes, my lord.
Where is what it has said?
Yes. Page 40, judgment was my annexure 4, my lord. Annexure page 26.
Amendment to the Constitution and insertion of Part 4, 9A. Since the jurisdiction exercised under the municipal law in respect of urban and town planning, opposite party number 3 can therefore be said to have erroneously exercised. Who is upon OP number 3?
Routledge Development Authority.
OP number 3, my lord.
Here.
In that case.
Therefore, said to have erroneously exercised the authority under the ODA and not made it by following provisions of the municipal law. Since the manner of exercise of the authority is not in accordance with such reservation of power, whose order it is? So the author of this was under which part of which is the constitutional provision he has interpreted? Give the constitution. But as long as this section remains, that section gives the power to demolish the structure.
By this power is delegated to here in Cuttack and Bhubaneswar. That power is delegated to municipal corporation.
Delegated under which section?
That power is delegated. It is by executive instruction.
How where is the power to delegate in the act? Unless authorized, where is the delegation?
Because here in this case, Miller, what happens? I filed a application.
You are not answering the question of law. Question of law.
In the different stages of this writ application, Miller, 5 rounds of the.
I do not know that. Where is the power delegated to the authority? You said it has been delegated to the municipal body. Where is the delegation? Which section?
There is a provision.
Show that.
The delegation is given by executive instruction.
Where is that?
That gazette notification I will supply. Let it come on Monday. I will give it.
On this matter, on Monday, in the second Monday of January 2026. Matter.
Sir, my lord, the OP number 2, on which order is the impugned here, my lord, they may be noticed because they are the deputy commissioner of the BMC.
Already noticed, all notices.
Notice has gone. He says notice is issued already.
They are the appropriate authority to
interim order to continue. But how that other coordinate bench saying that because of the constitutional amendment power, that does not make sense. It is covered by the judgment of Kerala High Court. Justice Mushtaq's, Honorable Justice Mushtaq Ahmed's Mushtaq's judgment. Just look into that and come back.
I'll file it. I am a intervener. Intervener may be allowed.
Application, intervention supported by affidavit is favored. Since it is on her complaint, the action in question has been followed. And therefore, she answers the description of proper party, if not necessary party, in the light of Apex Court decision in Rajia Begum versus Swine Society. Petitioner to amend the cause title, showing the intervener as a OP number.
They will be OP number 3.
3.
3, man.
You appear for
and I have the liberty to file the reply to this.
The newly added
I'll explain
OP
it.
may file her counter within 3 weeks.
Short date. Because on Monday I will explain everything.
When Monday you explain, but in January also so many Mondays will come. Yes.
So, I don't.
Yes. Item 27.
27 minutes. This matter can be disposed of. The same MSME. My prayer was for consideration of my MSME status. Now that has been resolved.
OPs for the OPs.
State is the main OP.
I'm for OP number 3. My learned senior, Mr. Rath, will be conducting the matter. My learned senior has also served me a copy of the similar order.
In terms of this order?
I have to verify it. Just now it has been served on me. I'm just praying for 1 week. Just
1 week.
one.
For verification of this,
Yes,
where is
sir.
the adverse order to you?
There is no adverse order, but we need to verify. It has just been served upon me. I have to verify it with the prayer, and I'm just praying for a short date. Obsequies will be over by 26th. On 28th, it may be taken up.
On 28th, they want. Call on 28th. It's the request of. Yes.
Forgetfulness.
Item 28, my lord, item 28.
Last
Last direction to the public school to instruction, the petition was accommodated by this board. Already, my lord, the vacancy, the petition, my lord, apply the admissions.
His instruction. He has provided copy to me. They are ready to, if they will apply, then they are ready to.
My lord, I will writing it.
In terms of this,
Yes, my lord.
Petition present.
counsel for the petitioner has filed a copy of the letter dated.
Counsel for the
OP number 4 has filed.
As per the direction of 17/11/2020.
The petition prayer reads as at. First, next paragraph. This court, while order dated 17/11/2025, had said as at. Next paragraph. In terms of the above order, now a letter has been letter dated 19/11/2025. 19 or 9/11?
19 minutes.
2025 has been
Para 2 minutes, the vacancy.
filed.
Para 3 minutes. The presently 22 students.
Which reads as an. First term. In next paragraph. In view of what has been stated in paragraphs 3 and 4 above, is, the petition has become infructuous and accordingly the same is disposed of.
No, my lord.
First term. The which school has to do that?
ITBT public school might have
disposed of. It is made clear that the ITBT public school classes 1 to 5 with vacancies available in each class is directed to grant admission to the petitioner upon submission of applications and also issuance of transfer certificates as per the extant norms. First of all, this to be done immediately.
One thing, that's that serial number 11. In the second read petition, which is attached with this case, he is stating that is the petition counsel. He is stating that at serial number of 11, where I have mentioned that he has not at all applied. No registration was there last occasion. Now he is coming that in the father's name, you are in the cause title father's name, but he has applied in the son's name. That has to be, he has to correct it in the cause title.
In the WP number 24310.
At serial number 11.
At serial number 11. The name of party at serial number 11 is to be rectified as a
Om Sai Krishna Balwantrai.
Om Sai Krishna Balwantrai.
And if Om Sai
instead of Tapas Kumar Balwantrai.
And his father's name is Tapas Kumar
Balwantrai.
And if you will see in the, you will see has to directly, if Om Sai Krishna Balwantrai is applied and registered, then as per the letter number.
No, rest of the things you have to give. Otherwise, all students will be put to death. In the order it should be. This should be circle.
And name
together.
For OP Kendriya Vidyalaya.
Yes.
29.
May I please, Lordship? Lordship, I am representing the petitioner in item number 29, Lordship.
Yeah.
The issue is related to the caste certificate of the petitioner, Lordship. Lordship, in the last occasion, on 19/10/2025, Lordship issued emergent notice to the OP's Lordship, as well as your Lordship directed the petitioner to serve the 6 sets of copies. Already we have served with serial number 448081 on the next day itself, Lordship. So while going to the facts of the case, Lordship, the caste certificate is very essential to the petitioner to submit the same before the counseling that is held in Telangana, Lordship.
His appeal is pending against rejection. He has already preferred appeal, my lord.
His appeal is pending.
Yes, my lord.
Your appeal is pending.
Yes, Lordship. First appeal is already pending before the collector, and also second appeal also pending before the RDC, Lordship, since that is 18/8/25, Lordship.
Therefore, we will direct them to dispose of the
Lordship, actually, the first appeal is also pending before the collector, and second appeal also pending. So, Lordship, may direct the respondent number 4 to dispose the appeal pending before them, Lordship.
Since a party counsel for the petitioner is online, it is difficult to communicate and call this matter in February 2026. Yes. Since you are online, we are calling it in February 26. Yes.
Lordship, meanwhile, may be disposed, Lordship, directing the respondent number 4 to dispose my appeal, Lordship.
He has approached my
Two
lord,
authorities.
two authorities.
Which authority should decide?
My lord, it is the collector who is the authority to decide it.
The rejection is by the person.
Petition prayer reads as that. Learned counsel for the petitioner submits that appeals before the collector and
RDC, Lordship. RDC, South Division, R4.
Wait.
My lord, the law is
South Division have been filed. When the later has no jurisdiction, you may have another appeal.
My lord, in fact, if the order is passed by the Tahsildar, then it is appealable before the sub-collector.
Yes.
If the order is passed by the collector, then it is appealable to the RDC.
But now it is passed by
Tahsildar.
Therefore, he has filed appeal before whom now?
Before the collector instead of sub-collector.
Then the collector send it to the or let him file appeal, another appeal within 3 weeks. You file appeal.
But Lordship, already I filed the appeal, Lordship. Collector has to, as per the act, collector has to decide within 30 days. If collector has not decided, then there is a provision as per the act, Lordship, we have to file the second appeal before the RDC.
Kindly have a rule 9
Delhi.
On 14th, yes, Lordship, I am representing from Delhi, Lordship.
You are representing from Delhi.
Yes, Lordship.
Yes, I have seen him for first time. Kindly have a look to rule 9 of the
1 second.
SCST manual.
If order is passed by the Tahsildar, appeal lies to the sub-divisional office.
Yes.
Is it correct?
Yes.
He has filed it before the district collector. Therefore, district collector should have sent the papers to the sub-divisional officer.
To the appropriate officer.
To the appropriate authority. Only one more appeal.
This can be also considered.
Yes.
This can also be.
He is the subordinate authority of the collector.
That's what. The appeal is, the grievance is as to the social status of the petitioner. First off, petitioner has preferred 2 appeals against the same order of the Tahsildar, one before the district collector and the other before the
region
RDC. So. First off, Mr. G. Learned AGA points out that appeal against the order of the Tahsildar lies to the sub-divisional officer under which rules?
Under SC and ST manual. Rules.
Rule 9.
Yes.
Rule 9.
Rules of 1980. Orissa caste certificate for SC and ST. Rules of 1980. Rule 9.
Line of Orissa so and so rules 1999.
1980.
1988. Give the entire this one. First off. Therefore, he submits that Rule 9. The appeal is filed before the incompetent authorities. First off. Next paragraph. Learned counsel for the petitioner in reply submits that if an appeal is filed before the higher authorities, comma, it is their duty to transmit the appeal papers to the sub-divisional officer, who is the competent authority under the subject rules. I agree. First one. Next one. In the above circumstances, the district collector is directed to transmit the appeal papers in number. Give the number.
Number is not there. Online he has filed.
Online provision is there, Lordship. Application dated 13/6/2025, Lordship.
Appeal dated
13/6/2025, Lordship.
2025 to the sub-divisional officer immediately. And on such a transmission, the sub-divisional officer shall hear and dispose of the appeal within an outer limit of 6 months. All conditions of the parties are kept out. Next.
Deeply obliged, Lordship.
All matters over.
On behalf of the petitioner, has some personal difficulty. On consent, list when this bench functions next. Next matter, Mr. Rupesh Kanungo for the petitioner. Then opposite party, Mahapatra. Same order.
Item number 3, my lord. Item 3. My name, even I have filed, the name doesn't appear. I not brought the file, my lord. Any next sitting, indicating my name, my lord.
When did you file Okaratama?
On 1/9/2025. 1/9/25.
Since long then?
Since long, but not.
You check it, maybe wrong number was mentioned or something, but
no,
record that. Yes.
Number is next sitting.
So Beura.
My lord.
Beura AGA for the appellant. Opposite party blank. It is submitted by Mr. L.K. Mohanty, learned counsel, that he has filed Okalatama. He has entered appearance by filing Okalatama on behalf of the respondent. R1.
Only one respondent.
Only one respondent.
On 1/9/2025.
The registry shall locate the Okalatama and bring it on record. Scanned copy be updated. You serve a copy. Beura? He says that he has instruction, you serve a copy of the appeal memo. Copy of Sapara, copy of the appeal.
No, my lords. Here, my lords, the appeal was disposed of by a judgment by my lords. He seeks modification of that judgment.
What modification?
I am a work charge employee. The case was.
Will file counter to the IA.
The disposal of case was disposed along with that JC employee. So
you are not appearing for the. You were not appearing in the original matter for the.
Original I not upload in the.
That's the problem.
And I read notice issued on 16 date 10/7, but order hearing closed 7/7 before my appearance. I received on 10/7. Before that date, hearing was closed. I have to batch cases.
You have to make the order in the IA.
Yes, IA only, madam. That only motive I want.
IA 3836 of 2025.
Only that I am received.
The IA has been filed by the respondent.
Madam.
Seeking modification of the judgment dated 15/7/2025.
Madam.
Modification or rectification?
Only rectification. That I am not included that order.
Rectification.
By that order of JC employee.
Proper sentence tag proper sentence it is submitted by Mr. L.K. Mohanty that the appeal filed by the state was disposed of before appearance of the respondent.
Thereafter, he has filed IA along with Wakalatnama. Registry shall locate the Wakalatnama and
you can allow the application itself.
registry shall locate the Wakalatnama.
You have an objection to that IA?
My lord, will file objection.
Registry shall locate the Wakalatnama and reflect name of Mr. K. Mohanty as Learned Counsel for the respondent in the cause list as well as the case brief. Mr. Behura, Learned AGA, seeks and has adjournment to file his response to the IA. The matter shall be listed when this bench functions.
Right.
Item 1.
My lord, in this case, your lordship on 10th July 2025 has passed the order and directed the opposite party's contemners to implement the order of the single judge dated 25/6/2024 within 8 weeks. So, my lord, we have already served the copies of the.
They have not.
My lord, what I humbly submit is a fresh matter. I will take instruction, but my humble submission is that this is a single judge matter, my lord.
No, where the division bench says, implement the order of the single.
That is what I bring to my lord's notice. Whether it will be because
you take notice.
Because the single judge order,
police notice should go to the party. You cannot appear. So whether private parties are
under writ appeal.
That's all right. Writ appeal say implement the order of the learned single. Therefore, the order of the violation is the order of the division bench. Contenders are who? Official capacity or
Principal Secretary, Housing and Urban Development, Government of Odisha.
File requisites. The petitioner alleges non-compliance of.
If you want to appear.
my lord, I will take instruction, my lord, whether it is implemented because the application was filed in September, my lord. Now this is.
Whether it is complied or not.
In the petition, it is alleged that order dated 10/7/2025, passed in writ appeal 3351 of 2024, has not been complied with. The learned additional government advocate upon advance copy served appears and submits that he shall obtain instruction regarding compliance of the order. Accordingly, we are not issuing any further notice at this stage. Yes, Mr. Behura?
My lord.
Next sitting.
My lord.
The matter shall be listed when this bench functions next.
Next date.
No, we cannot fix a date. That's a it's not a regular bench, so that we are.
This is accidental bench.
Item 2.
It is 610/2025.
Just from the respondent, that's why I filed this IA 610/25 for recording the payment of the permanent alimony.
What was the order?
Received the said appeal was disposed of 24/7/2025, and this honorable court is in his order dated 24/7/25 directed the respondent to pay the rupees 10 lakhs towards expenses of his daughter.
How much?
Rupees 10 lakh.
10 lakhs. You have not paid.
I have already paid.
You have already paid.
This month.
That has been received by the.
You received now?
Yes, ma'am.
Why this is posted today? For reporting compliance?
Yes, ma'am.
Huh?
Yes, ma'am.
He's contemplating second marriage. So now the wife is complaining that still you have something in court or what? This is a very unusual IA, very, very unusual IA. You are not seeking any direction from the court, not modification of anything.
What is that IA?
So 610.
610 of 24.
We don't acknowledge. Courts are not to acknowledge.
So
the respondent, the other side will acknowledge.
No, if he can, of course, we have not accepted, therefore we will not acknowledge. But if he says that he has acknowledged it, we'll record that and dispose of the IA.
Sir, kindly pass on appropriate order regarding this IA. Kindly pass on appropriate order regarding this IA.
What is that appropriate order? He says that he has received. IA disposed of. Perfect. Right now. Martha number 80 of 2014 was disposed of finally by the order dated 24/7/2025, under which totally a sum of rupees 10 lakh was directed to be paid to the daughter, daughter of the parties. First time. Learned counsel for the petition, appellant stroke applicant. You are for applicant.
I'm for the respondent.
Respondent.
Applicant respondent.
Applicant respondent, husband, submits. And learned counsel appearing for the appellant's wife.
Yes, ma'am.
Admits that the amount of 10 lakh as specified in the order above has already been received by the wife.
By the daughter, ma'am.
By the daughter. What is age?
She's 21, 22.
By the daughter. What is name? Ananya.
Ananya Acharya.
Miss Ananya Acharya. Acharya. First one. Next paragraph. In view of the above, application is disposed of.
Grateful.
Item 4. You won't even pretend it happened. So we won't get money.
And the respondent husband has filed the IA number 493 of 2025 seeking variance of the order dated.
What was the order?
Order the matrimonial appeal was disposed of by order dated 25th June 2025. And
what the order?
On the agreement between both the parties, that the custody of the minor child will be with the wife and the husband will provide the maintenance for the wife as well as the minor child and to meet the study expenses. And accordingly, your lordship has disposed of that appeal, and while disposing of, has granted the liberty to both the parties to seek for any variance of the order if circumstances so arise. Now,
what variance you want, and what is the ground on which you structure your prayer for variance?
Kindly have a glance to para 4 of my IA number 493 of 2025.
I may be pardon your lordship, I'm appearing for the appellant wife. No, they have not served a copy upon us.
Also,
you should always serve the special bench matter. Now time is wasted. 2 courts are wasted now. Brother cannot sit in his court. I cannot sit in my court.
Sorry, I'm sorry.
What is all right? Let us see whether it is maintainable or not first. Convince us that this application is maintainable. What is the change you want to have?
Para 4, I have taken the ground A to F. So, may I place it? The grounds which I have enumerated in interim application.
the child is not admitted to the school.
So far as my instruction is concerned.
What do you say?
My
Admitted
lord,
to school? or not?
he has already been admitted at KV1, second shift. He's already been admitted. One second shift.
Difference that you are calling it central school, she is calling it Kendriya Vidyalaya.
That's all.
And as usually it happens between husband and wife, for that also there is rockers fighting.
Second
Whether it is a Vidyalaya or a school.
Second aspect is
Yes.
through the wife in her pleadings before the land trial court as well as before this whole court has pleaded that she is having no independent source of income. Lordship, kindly have a glance
So
to that.
the question raised by my lord is answered here. This is not maintainable. You want that 25 provided. In subsequent events, you can seek modification.
No, the Lordship, while disposing of this appeal, has granted both the parties to liberty to seek for
liberty regarding this order.
Yes.
Not the cause of action which will arise because you say that now she has become richer than me. I will seek. You can seek always maintenance from her also. We don't know.
That I am not disputing. But throughout her pleadings, she has stated, though she is quite qualified, but she stated
because and you have changed, and she has obtained a change. The recall and review should be argued by the same council. Because the responsibility has to be taken by the parties and the council also to stick to their stand.
The earlier council who has been engaged by the respondent has given a consent.
It makes no difference.
It makes no difference.
Supreme Court says in any variation, the same council should
I have that decision number.
The same council should appear.
You see, in fact,
unless he is dead.
No, in case of no objection, Lordship.
In review.
Yes, review variance. This is 1997 9.
No, this is overruled. That's overruled. Very.
Well, here also, para 2 last part. Filing of the no objection would be the basis for him to come on record.
No, you have to check the latest
position is a bit different because what all happened between 2 judges and between 2 lawyers will be known to each one of us. If he comes, we can tell what that.
But in case I have no objection with me, thereafter I file this application.
All right. Then the application is not now the para F is complied with. Other things do not have.
So far as the income of the now she is earning. Future capability of husband or wife is never a criteria for Section 25 matrimony. There is no precedence. You practice in this branch. I think Mr. Bag also is capable enough to cite.
So far as the minor child is concerned.
No, we are not answering you. But when you are asking future capability of husband or wife is to be considered and varied as far as 25 is concerned, is there any precedence? You have to answer that.
No, that is
not maintainable.
I'll verify whether there is a precedent on that aspect. But so far,
your application is
hardship is concerned.
Just guesswork.
Since I am working as a constable.
Can you check 25? Because the problem is that you have made it a writ petition. So it's not a writ petition, it's a statutory appeal. 25 of Hindu Marriage Act. And this is a settlement between the parties. That is the settlement important aspect.
That we don't interfere in settlements at all. Variation means some new circumstances should arise.
25, your petition is akin to, I mean, you have not referred actually any provision in Hindu Marriage Act, but it is a petition under that you have not mentioned under which provision you are seeking.
25(1), there is a variance. 25(1).
Which part you are seeking? Leg one.
No, this is a consensual order.
Yes, consensual order, but the change in circumstances now the wife.
Tomorrow the husband will win a lottery. The wife will come up with a case that I will have a share. You have to have a mirror. I mean, what is the logic you are propounding?
Because the divorce
you are saying that the wife has started earning, so I will not pay.
No.
She
I will be
earning earlier.
to the minor child is concerned.
Not minor, we are not
But
discussing minor.
he is
Again,
now
again.
self-sufficient
No,
and is earning.
So where is that? Where is that provided in 25(2), 25(1) and 2? That future earning of wife, suppose tomorrow wife will come. Now, just imagine. They will file a petition that recently in that lottery in Mauritius, he has won 100 crores Indian currency.
Yes.
I need to have this 50% share because on the date, because still he is too liable to maintain as per 24 and 25, 10 circumstances. That is, we will not entertain the half petition. We will not entertain half petition.
Similarly,
suppose you have someone, now your wealth is discovered. Your wealth is discovered, there is a raid in your house, husband's house. 8 crore cash is received in Hyderabad biryani. So now see, he wants that much of money. So what will be the estranged wife of the biryani chain owner will say?
Well, my submission with Lord is the hardship is concerned. It can be taken into consideration that
case law
has directed, I am complying with the order.
Mr. Patnaik, we have a lot of hope on you. You have to substantiate your case with some case law that because there is no such precedence. Because then
may keep it to area that I am solving a
point. There is no point. You see, and also suppose you express anything opinion on merit.
Yes.
Then 25(2) is a bar for you. Because 25(2) is future. You say 25(1), it's not 25(1). If the court is satisfied that there is a change in the circumstances of either party at any time after it has made an order under subsection 1,
order changes.
Post this at the instance of either party vary, modify or rescind any such order in such manner as the court may deem just. Then 3 is that till marriage, either of the party marriage.
If they will remarry, then there is no application. But here, appeal is a continuance of the original procedure.
Dispose of appeal is not a continuance of appeal.
Matter is disposed of already.
25(2) is the original code. Then we will be depriving both of you a appellate forum also. Because again 25(2), because as they love fighting each other, then up to Supreme Court they will be fighting 25(2), fighting to 25(2).
There is nothing.
These are the two grounds. One, she stated that yes.
Affidavit filed by the husband seeks variation of our order dated so and so, whereby Mata was disposed of with certain conditions. That's first. Learned counsel for the petitioner submits that the variation liberty is reserved in the judgment itself, and therefore this application is moved to demonstrate that the wife was earning when the order was made. First off, he also tells the court that the ward is not admitted to Kendriya Vidyalaya, and therefore the order needs to be varied. First off, next paragraph. Learned counsel appearing for the wife opposes the application, contending that the ward is admitted to central school, which is none other than the Kendriya Vidyalaya.
Mr. Patnaik says central school, she says Kendriya Vidyalaya.
That's what. The counsel for the husband employs the native language Kendriya, whereas the counsel representing the wife employs the foreign language central. Except this, there is no difference at all. And that would not constitute a ground. First, next paragraph. The variation contemplated under section 25(2) of the Hindu Marriage Act 1955 is such variation as would occur post-judgment. First, pre-judgment factors are not within the precincts of section. First, next paragraph. First, added, the judgment is consensual, and therefore in matters of consensual orders, Apex Court has time and again warned that interference is not to be granted, subject to all just exceptions into which argued case of the applicant does not fit. First, in the above circumstances, application being unworthy of consideration is liable to be dismissed, and accordingly it is.